Well, good morning, everybody. We are here on our YouTube channel, ACE's YouTube channel live. Welcome, everyone. I hope you're all watching or that you're coming on to join us for this really exciting conversation this morning. I've wanted to have this conversation for a very long time since we started ACE. Um, I'll tell you a little bit about myself. My name is Jennifer Wigmore. I am the co-administrator of ACE, which is the Association of Acting Coaches and Educators. Our wee little organization is helping to build respect-based coaching as the standard of practice here in Canada and the world. And we have a very exciting 135 members so far who are helping to bring respect-based coaching practices and a commitment to ongoing education of themselves to the sphere of acting training education. And so if you haven't heard of us and you're just joining us, I hope you'll come over to our our website and learn a little bit more about us and what we're trying to do to change the landscape of acting training education in Canada and the world beyond. Um, so back to this great conversation. Um, as I've talked to many coaches and educators across the country and being one myself, I know that many small coaching businesses start to grow and they start to grow and turn into larger coaching businesses where you maybe hire a few people and bring them into your world. And then suddenly you're running a studio with 3 or 4 other teachers. And that changes things. The minute you move past yourself, you become an employer. And I think a lot of acting coaches and educators are very surprised when I remind them that they are employers now. And they just don't have the context for which to begin to even open that conversation for themselves. So I think it's time that we talk about this and that we talk about some of the policies about labor law, that the because of the Me Too movement, we have to really talk about harassment and discrimination within the workplace and the laws that have changed in order to protect workers and students. And so we really need to open this conversation and not be afraid of having it, because I think that's part of the problem is that we haven't had these conversations. We haven't talked about this stuff because it's scary, to talk about labor law and, harassment policies. And there are things you have to work on. So I just think we should just rip off the Band-Aid. And so I decided to have this conversation and bring in some friends to help me. Um, the first place I reached out to was AACE Ontario, which is an incredible organization that's been running for 40 years. And I asked our friends at AACE to come and help us have this conversation. And thank you, Tyler Kowalchuk, for coming and agreeing to that and pairing us with Madeline. I'm wondering if you take a moment and tell us a little bit about AACE Ontario and the work that you do over there.
Sure. Thank you, Jennifer. Yes, I'm Tyler Kowalczyk, and I work with AACE Ontario as a program coordinator. So AACE, as mentioned by Jennifer, for about nearly 40 years now, has provided summary legal advice, education, and legal resources to artists across Ontario. So all of our programming is free and is open to artists and creatives across all disciplines. So our main programs include our legal clinic, which offers 30 minutes of free summary legal advice with volunteer arts and entertainment lawyers, and that clinic covers the majority of areas of arts and entertainment law, from contracts to intellectual property and any other related issues. And then we partner with arts organizations to deliver legal education sessions such as these. So thanks to ACE for reaching out and partnering with us on this session. And then we have a growing legal database of resources that cover a range of topics that we commonly see from artists. So these could be guides, articles, tip sheets, those types of things. And we're looking to grow that in the future. But you can check out our website at alasontario.ca, and you can learn a bit more about our programs and what we offer, or you could always reach out to the contact information there if you're interested in learning more. So thanks for everyone for attending today, and thanks, Jennifer, again for inviting us, and I'll hand things back off to you.
Thanks so much, Tyler. We appreciate it. And yeah, I will definitely provide a resource list of everything we talk about today, including the fabulous website of AACE. And they have some very, very good resources on that site. So please check it out. That will be on our website. I want to introduce our two guests today. We're very lucky to have them here with their depth of expertise. Madeline Werker is a laborer in law, labor lawyer in law, a lawyer in labor and employment law. Holy moly, there's a lot of L's in there. I speak for a living. Madeline is a senior associate lawyer at Borden Ladner Jarvis LLP. Oh, wow. And she represents and advises unionized and non-unionized employees in the private and public sectors on all aspects of labor and employment law, including human rights. Madeline volunteers pro bono with Pro Bono Ontario and is the former editor of the Ontario Bar Association's Labor and Employment Law newsletter. She's also a board member of 2020 Arts, an organization that produces multifaceted public art, fundraising, and education campaigns addressing mental health, homelessness, and addiction. Madeline was recognized in 2025 edition, the upcoming one, of Best Lawyers, Ones to Watch in Canada. Thank you, Madeline, for being here with us today.
Thanks, Jennifer. Nice to be here.
And then I would love to introduce you to my dear friend, Ruby Joy. I met Ruby Joy when we started working together with Got Your Back right after the Me Too movement. And both Ruby and I fell madly in love with harassment law. Aren't we such weirdos? And we really became fascinated with the processes and the policies of harassment and how they function within artistic spaces. And we became really good pals because of it. And then Ruby went on to become a lawyer because of it. And I'm just so incredibly excited and proud that you're here with us today. Ruby's a dual citizen, both of Canada and the US. She's the offspring of actors. She was an actor herself. And so that has really been the foundation for her practice as a lawyer. She spent 5 seasons at Stratford and is still living in Stratford. She worked with Got Your Back with me and at ACTRA and CAEA. And she's gone on to become a lawyer at her own right at KDB Law in Stratford. And we're just really excited that you're here to bring your expertise and all the things that we love to talk about, Ruby. Thanks for being here.
Thanks, Jennifer. It's a pleasure to be here.
So here we go. Let's open this up a little bit. So I think some of the problems that happen with acting coaches and educators is that they never really expect to become a business. I think that they think of themselves always as self-employed contractors and artists. And even in their teaching practice, they consider themselves an artist. And so when their business starts to grow, and it usually goes quite organically and without even really realizing it, they hire a friend, and then they fill their class, and so then they have to add another class, and they can't teach it, so they ask a friend to do that, and then before they know it, they have several people working with them in their studio. And I think that there's a lot of issues that change as soon as you become an employer. Or, well, I think the first port of call is you have to recognize that something has changed and you have become an employer. So I guess some of my questions, and a lot of what we're going to talk about, is what does the labor law say? Let's just clear it up. What does the labor law say when you hire anyone, whether they be a self-employed artist themselves, or a subcontractor, whether they're on a contract or not, when you hire anyone, what are they considered according to labor law?
All right. Well, I think the first thing that I want to touch on, because we're lawyers and we love to be specific about things, is this distinction between labor and employment law in Ontario. And I imagine some of your members are familiar with some of the unions that they're in. And so when you're dealing with a unionized workplace, that the label that we would attach to that kind of environment is a labor law environment, where you've got this classic relationship between a union, a group of employees represented by an association, a union, and the employer. In that case, would be the management side. Then we have the world of employment law. And that's a world where we have individual relationships between employees and an employer. We're dealing directly with each other. We don't have a union involved as an intermediary or a representative. So that aside, there's this next set of questions about, have you hired someone? What is that relationship? So there's three categories generally that we have in Ontario. We have an independent contractor relationship, we have a dependent contractor relationship, and then we have an employee-employer relationship. And there's all kinds of things that can happen, and it doesn't necessarily matter. The law says how the parties envision the relationship. It ultimately matters what the relationship looks like. And so when we are looking at whether a relationship is one between an independent contractor and an employee, an employer, there's a legal test that courts will look at. They'll look at a couple of factors. They'll look at whether the relationship is one that requires exclusivity. Are you hired to work only in my studio? Are you required to work a set number of hours a week? Are you required to work only in my studio? Do you provide your own tools, or are you coming to my place of work, my studio, whatever that looks like? Am I providing you with a laptop, an email address? What is the risk that you have in the business? Are we running this enterprise together? If students don't sign up for your class or don't come, are they still paying? Who's bearing that loss? So these are some of the things that a court is going to look at. And the more that someone has control, the more that someone is saying, you work only for me, you work these hours, you work in this place, I will provide you with whatever you need to do your job. And whether someone shows up or they don't show up, that lands with me. It's going to look more like an employee-employer relationship, where you have a general task, you can conduct that work on your own time, where you choose, you're providing your own tools, whether it's a laptop or props or a camera. Great. Thank you, Jennifer. Those are some of the things that a court might say, this looks more like an independent contractor relationship. There's also this hybrid, which is a dependent contractor relationship. And that's usually where someone is reliant on one source for a significant portion of their work, their income. And so you're towing this line between, yes, you're in some ways a contractor, but you are more likely, the courts will find, to have some entitlements as an employee, and therefore some obligations as an employer. And the most important obligation tends to be notice. That's when the relationship goes sour. So I'll leave it there, and I'll let Ruby or Jennifer or take us in another direction.
See how complicated it gets? And then I feel like acting coaches go like, no, please stop. No, I can't. They're out. And so I think the most important thing that I got from what you said, which is like a lot and really important information, is that if you're hiring somebody to work in your studio, they're more likely somebody you're employing. If you're giving them the tools, you're scheduling it, you're taking the money, you're doing all the processing, you're providing the camera, you're asking them to teach for you, you're their employer. Like, because anything else is kind of like possibly maybe, but it's actually more likely. And if you do that repeatedly, you do it more than once, like they're teaching more than one class for you or over a long period of time, that they're more likely your employee. And you should just kind of think of it that way. What do you think about that statement?
I think that's likely the safest way to go. Again, it depends on the specific. It also depends how the person who's coming in and doing the teaching on a contractual basis, where that fits into their matrix of income. If it's a couple of hours a week for them and it's occasional, even if you've got a couple of years there, if the bulk of their income is coming from another source, whether it's, their own acting jobs or work for other studios, I think, you've got that exclusivity piece, and that's going to take the court's analysis in a different way if it comes to it. But there may be some reasons to, off the head, commit yourself to being an employee-employer relationship. Ruby's got a great theme for today, which is, about managing expectations. I think it's a super way to think about this. And so if you are entering these relationships with folks, if you're being upfront about what the arrangement is, then it can save a lot of headaches down the road.
Oh, big time. Yeah, let's talk about that a little bit. But Ruby, did you want to comment a little bit more about that, this idea of being
I was just going to say, if you're a studio owner who has their own physical space, as Madeline was speaking to, you're providing the camera, you're providing that, versus if you meet on Zoom, for example, but you might still be providing your worker with a computer, the email address, the link, etc. Each of those is different factors that the court is going to take into consideration to try and identify what the employment relationship is.
Right. Yeah. Okay. That's really helpful. So, okay, let's just go ahead and assume that we've decided that we have employees, that, we hire 3 coaches who work with us pretty regularly, and we provide the space. We have some in-person classes, we have some Zoom classes, but we have a regular group of people who are now our employees. So what kind of policies and procedures are required to have in place when you start hiring people? Like, what should you, just as a baseline, have when you start hiring people on a regular basis?
There's 2 buckets, and the first bucket has policies that are required of you as an employer, and then within that there are some that are, the second you've got one employee, this is something that it's required that you have in place, and then there are some where, at certain thresholds you're triggered to add a couple more. The first ones primarily that I want to highlight today are a health and safety policy, a workplace violence prevention policy, and a workplace harassment prevention policy. Now, there's some people who will say, so long as you've got fewer than 6 employees, it doesn't have to be in writing. When more than 6 employees, it must be in writing. I think the best practice is manage expectations, commit yourself to putting things in writing, because that way, if you are faced with, a workplace violence issue or a harassment complaint, you know exactly what you need to follow. In my experience, these complaints will come out of left field. They'll be contentious. And so the more that you have in writing to be able to make sure that everyone is on the same page in terms of, here's how we're going to go about investigating. Here's what that's going to look like. Here are the timelines. A general rule of thumb when it comes to these prevention policies in writing, and be clear about the steps, but don't commit yourself beyond what you have to. Don't necessarily commit to, within 3 days we'll investigate. Within 10 days we'll get you a written decision. Don't overcommit in terms of the type of information you're going to provide. But the Occupational Health and Safety Act does provide for a few requirements that you are notifying the folks involved in the investigation, whether they're the complainant or the respondent, of the outcome in some form or other. So that's what I'll say about those initial policies. Where you are beyond 25 employee threshold, these are new in the last couple of years. We've got an electronic monitoring policy that can be very bare bones. Often they're just a single page, but something to keep in mind, as well as a disconnecting from work policy. So those two are over the 25 employee threshold, and over the 100 employee threshold would be the Pay Equity Act policies. I don't know how relevant those are, but I wanted to make sure that we covered all of those required policies.
Thank you for bringing up harassment law. We are going to unpack harassment law in a pretty major way in a few questions to come. But I do want to talk a little bit about contracts, because I think that even small coaching studios have verbal agreements with their teachers, and I think that that's deeply problematic. You've got to get beyond that. You've got to protect yourself and your business a bit better by getting some things in writing. So how important are employment contracts, even for, one class?
Oh, contract law is a whole beast. Ruby's laughing, but it's true. The employment law world is this wild world where contracts matter. What also really matters is the legislative scheme that we're operating within, because the Employment Standards Act stipulates what things can be contracted out of and what things cannot be contracted out of. So that's the environment in which these contracts are existing. You can't ignore that. At the same time, there are common law obligations. It's law not in pieces of legislation, but law that's made by a series of decisions made by judges that also provide this default net that we otherwise will fall in. And so what contract law allows you to do, it allows you within the confines of what the legislation requires of you to otherwise float above that common law net. And the benefit to employers in doing that is that common law is very generous to employees in terms of what it's going to say that they're entitled to when the relationship comes to an end. And so where you have a contract, most of the time I'm flipping right to that termination agreement, because it's uncomfortable to think about the end of a relationship when one is just at the outset, but it's a worthwhile exercise so that if and when that comes to pass, whether because the employee or the teacher is moving on or the studio circumstances have changed, everyone knows, kind of like those policies we were talking about, everyone knows what's going to happen. Here's what you're going to get in terms of notice. It's really important when you're setting out your plan for parting ways that you have a view to what your minimum obligations are under the Employment Standards Act, because where your provision is offside in any respect, it will not be something that you are able to rely upon.
Right. Ruby?
Yeah. I was just going to chime in and say that I think in many ways, if you have a contract with an employee or with a self-employed contractor, it's always a good idea to put it in front of the eyes of a lawyer to make sure that, again, the legislation and the common law and whatever you as the individual business owner desire are reflected in that contract in a way that can be legally upheld.
Mm-hmm. Yeah, and I think, the good news is, while that's an output of an expense, you can use the same contract over and over again for your employees in the future, right?
Yes, although we're always hesitant to treat them as templates, but yes,
but
just I don't hear that. That's fine.
Yeah. That's okay. Just plug your ears. Yeah, I mean, I think creating a template is very helpful, because we have to remember that studio owners are overwhelmed. They're small business owners. They're running a new business. They're catching up with employment law. They're trying to figure out their policies and procedures while scheduling classes and branding and it's a lot. It's a lot going on for them, and so I think that this is stuff that falls to the wayside because it's paperwork, and artists are allergic to paperwork. We just are, because we don't do it. We have other people do it, like agents and managers and our union,
Yeah.
And so we're really allergic to it. But I think that what I want to emphasize is that it's about actually protecting your business and protecting yourself as a business. Because if a contract goes south, it can be devastating to your studio and to your business, right?
Yeah, I think one last thing to add, if someone is looking to go down a contract route, after you have it reviewed by a lawyer, make sure that you have it signed before the person starts work. Because if it's signed after they start work, you cannot rely upon it.
Good tip. Good tip. And you can have a contract that's ongoing, right? So like that reflects multiple different classes, for example. You know, if you have a teacher that you hire at your studio and they're hired to teach multiple classes, you can have that be reflected in the contract, right? You don't have to do a new contract for every class.
That's a great question, Jennifer. This opens this question about whether you're having, a fixed term contract. Are you hiring someone specifically to teach class A? Once class A ends 12 weeks from now, the relationship is over, no further requirement to provide notice. That's one way of doing it. What happens though if class A is postponed 1 week? Then you're working a makeup class. It gets complicated sometimes where for whatever reason it doesn't end on the date that we said it would end. Okay. The other option is that you have an indefinite contract or a contract of indefinite duration. I'm hiring you now, and then you have a schedule to that agreement where you're saying here are the classes for the foreseeable future, class A and class B. That would require you to provide notice when you want to end that relationship, but it's a little bit more clear in terms of what your obligations are. The danger with a fixed term contract is if for whatever reason the relationship doesn't end when that piece of paper says it will, is you're falling into that common law net. And so you are no longer able to rely upon that contract that you've otherwise put a lot of work into. So to go back to your question, it depends on what your setup is. I think generally it's going to be better to have a contract of indefinite duration where classes are going to come up and you're going to slot people in. There is unfortunately for employers some case law that says where you have folks on and if you line up a bunch of fixed term contracts, you're going to teach class A, you're going to teach class A again, or you're going to teach class A again. The law says that's a contract of indefinite duration. So you can break it up into little chapters, but at your peril, you would assume that you don't have an ongoing employee-employer relationship.
Okay. Yeah. Ruby, any other thoughts about the contracts?
I think Madeline summed it up quite nicely. I think that's it's just something to consider, and I'll leave it at that. It is a very broad area of law. I chuckle when Madeline said it depends. We always joke that's the most lawyerly answer possible. And another phrase is at your peril, which I appreciate too.
Yeah, I think that's the moral of the story, right? I mean, if you have nothing in place, you have nothing in place, and that could be bad, could be good, but do you really want to take that chance? Let's move on to my favorite topic, harassment law. Why do I love it so? I find it fascinating. I'm so excited by some of the incredible changes that have happened in Ontario in particular, but across the country in terms of harassment law in the workplace. And I feel like acting studios are in a bit of a gray area when it comes to harassment law. We have some very strong protections for universities and colleges when it comes to harassment policies. And those protections extend to accredited colleges, which are some of the smaller, not as big as a university or a college, but are, schools, trade schools, for lack of a better word. But there's only a very small handful of those in Ontario and across Canada, frankly, for acting. So the majority of acting studios and schools are small ones that sort of fall in a gray area in terms of harassment law. However, where they don't fall into the gray area with harassment law is when you have employees. Da, 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 da. And so while your students may not be covered, your workers are. And if you have employees, you must, according to law, have a harassment policy or an anti-harassment policy or a workplace safety policy that includes a harassment policy. Is that a fair statement?
I'll pipe in. I will again echo Madeline, what she said earlier. You know, you should have a workplace violence policy, a workplace harassment policy, and a safety policy. There are issues, again, as she said earlier, about the size of your employment, right? So, for example, the Occupational Health and Safety Act, which we'll be talking a lot about in this section of today's chat, that the employer shall prepare a policy with respect to workplace violence and workplace harassment and review the policies as often as is necessary, but at least annually. And then the next section says the policy shall be in written form and shall be posted at a conspicuous place in the workplace. However, that written form and posted does not apply if the number of workers regularly employed, which is, again, let's look at that language, regularly employed, at the workplace is 5 or fewer. But again, as Madeline said earlier, it's very important. You know, it's a should case. It's in your best interest as an employer to have a written policy that your workers are aware of in terms of harassment. And I've provided Jen with some links, and I'll just read through the Occupational Health and Safety Code of Practice, which is one of those links that I provided to Jen. The program should include measures and procedures for workers to report incidents of workplace harassment to the employer or supervisor. If the employer or supervisor is the alleged harasser, it should include somebody else to report to. And set out how incidents or complaints will be investigated. And this is, again, I think one of those spaces that small businesses often come up against, which is you do have a duty to investigate the complaint. And as a small employer, that can be an internal investigation. Larger employers also tend to opt for a third-party investigation. So you can hire somebody to investigate the complaint on your behalf, so there's no alleged internal discrimination within the workplace. But even if you are currently unable to afford that third-party investigator, you must have somebody to investigate the complaint within your workplace. Madeline, I see you nodding. Did you want to jump in?
No, just agreeing.
Okay.
I am agreeing as well.
Yes. Yeah. Lawyers are like, yes, put it in place. And then once that investigation is complete, you as the employer have to give a summary of the findings of the investigation. And this is also a point when I think many complainants are like, they just told me the result. And you're going, that's what you're entitled to, is a summary. You're not entitled to every piece of text or every piece of evidence that the employer may have come into. But you are entitled to a summary, and your policy should lay out if there's, I'm forgetting the word, like a corrective action. Yeah. If there's corrective action that you as an employer wish to take, that should be laid out in the policy. Again, these are things around managing expectations, right? If I'm a complainant, I want to know what process I'm being taken through. If I'm the alleged harasser, I also want to know the process that I'm going to be taken through. And one very important thing that I should probably have said at the beginning is the definition of harassment under the Occupational Health and Safety Act is engaging in a course of vexatious comment or conduct against a worker in a workplace that is known or reasonably known to be unwelcome.
Mm-hmm.
I think it's incredibly important, whether that's in a code of conduct and or the workplace harassment policy, to know what standard people are going to be held to,
Mm-hmm.
including yourself, which is, again, what Madeline spoke to of make it something that you can comply with, right? Make it something that is reasonable within your scale of business to adhere to. Because
Yeah.
the law
And
likes it when you can follow your own policy.
Yeah, and I think that's an incredibly important detail is that I think a lot of harassment policies get overly complicated, and especially in a small business environment, it can get not only complicated but expensive to fix if there's a problem. And I've spent quite a bit of time working on harassment policies for small businesses, especially small acting studios, trying to find what is a workable model. I mean, I think there are many different kinds of models of what an investigation can look like. But I think the most important thing is to try and make it as simple as possible in order for it to be effective. One of the amazing things about having a working harassment policy, and we're starting to see some of the stats come out now about it, is that they actually work as effective deterrents. Because what happens is if people are if your workers are aware, and your students, we'll talk about students in harassment policies in a second, but if they are aware of an existing harassment policy, what they would do if something happened to them, they feel safer. They feel more supported, and they will more likely to speak up in the moment if they can to resolve something. And we know that so many instances of harassment are actually miscommunication, and can be remedied if people talk and address it in the moment. And it's when things move past beyond that initial moment and they grow and grow and grow that they can become litigious. And so I think one of the things that I'm starting to see in harassment law is that it functions as a deterrent to actually reporting, because people are more likely to resolve things in the moment. Would you say that things that might be something that you're seeing in harassment law?
I'll say from a legal analysis point of view, the lawyers like documents. We like language. So if it's always easier when I work a lot in employment termination cases. And so if an employee comes to me going, I don't know what just happened to me, help, I tend to look at the employer's workplace harassment, workplace violence policy, and then using the fact summary that I've received, I compare how that employee was treated to what's laid out in the workplace policy, but also, as Madeline registered, what's required by the legislation and the common law. So that's how I analyze those situations. And I think, again, where it gets muddy is when it's muddy. I know that's such a silly way to think about it, but when the expectations haven't been laid out clearly, if an employer hasn't abided by the legislation, that's when the employer has opened themselves up to liability.
Right. What do you think, Madeline?
I can't say that I'm aware of situations where employers, by virtue of having had such policies in place, have had employees sort of magically resolve issues as between themselves. Not to say that it doesn't happen. It just those tend not to escalate to the point of perhaps needing to involve me. But I think what makes a lot of sense is that having these policies in place would function as a form of deterrence and otherwise would be perceived by employees as supporting them within the environment.
Yeah. I think let's talk about students for a second, because it is technically, students are not included in a worker harassment policy. However, that doesn't mean that you shouldn't include them. And there are a bunch of reasons why that is so. It is in the best interest of your business to have some sort of harassment policy that also covers your students. Because you are going to have student to teacher relationships that you're not going to be part of as a business owner. And you are not going to be in those rooms watching every minute of a teacher's class that you've employed. And so it's important for you to have some sort of policy that protects students. It's also the right thing to do. If you have if you have a harassment policy for your workers, your teachers, by extension, you should also have those for your students. It just makes a much safer environment and allows everybody to feel supported within an environment of learning. And it was you, Madeline, that reminded me that in the absence of a harassment policy for your students, the Human Rights Code would be the default, correct?
Yes, as both as an employer, both in the employee-employer relationship, rather, you'd be subject to the Ontario Human Rights Code, and also as a service provider. So if we are not dealing with a formal education scenario, then I think the law would say that this studio is providing a service to its students, and as a service provider, those students are entitled to services free from discrimination for any number of the enumerated grounds under that code.
Hallelujah. Thank you. Because I think it's just so important for studios and schools to really get this in their brains.
I think what's really, oh, sorry, go ahead.
No, you go ahead.
What's really interesting to me about education scenarios, and I have a big group that I work with at my firm that specializes in this area. I'm not in that group, to be clear. But what's really neat, right, is you've got a relationship between the studio and the students, and then you've got the relationships between the students and the teachers that have been alluded to. And also in that relationship, the studio has an obligation to teach, to keep rather its teachers safe from harassment. And so that's where I think there are a slew of optional policies that some employers have. Whether or not you implement them in your workplace is going to depend on, what your workplace looks like. But I think a big one that I've seen recommended on the Ministry of Education website that has some policies and procedures that may be worth exploring as studios and studio owners is a code of conduct that applies to everyone, because that way you can codify some of the expectations that you have. And we'll get into how you are managing your students' expectations as we continue in the discussion, but that could be a document that you incorporate, for example, into your student application, or however it is that you're running that administrative practice.
Yeah, my very next question was going to be about what are the policies that we should have, and a code of conduct. It's huge. It's a huge document for any studio and school to have. And this is not, some of the codes of conducts that I've seen are that studios have are the student shall not. And that's not what it should cover. I mean, maybe it should cover those things, but that's not how you should approach it. It really should cover everybody. It should cover the teachers and the students and the administration, and how everybody is supposed to treat each other. and how everybody is supposed to behave. And then you've got it covered. We'll provide a number of examples of codes of conduct specifically for acting studios, because the very nature of what we do is slightly different. And I think that's why we get nervous when we talk about this stuff, because inherent in the acting craft is the exploration of the self and human emotion. And that can get very muddy when you're trying to talk about how you teach somebody those things. And you can bring up emotions. And so I think it's very, very vital to have codes of conduct that really outline behavioral practices that your studio expects and will abide by. Ruby, do you want to jump in here?
I mean, I think that's precisely it. Again, the code of conduct is a way to manage expectations so that everybody who you're welcoming into your space, worker or student, knows the expectations of how they're going to be treated, how you're going to conduct yourself. And when those expectations aren't met, they're able to point to it and go, I see that I either behaved in this way or I received treatment in this way that wasn't in line with the code of conduct. And then there can be a conversation around the incident.
Right. Yeah. What other policies? So we need a harassment policy, anti-harassment policy. We need a code of conduct. What else do we need?
There are a couple that I think are at least worth sort of turning one's mind to when you think about how you're going to be engaging with your teaching staff and your students. How are you going to deal with attendance and tardiness? How are you going to deal with overtime? What parameters are you placing upon your staff and the relationships that they have with students? If a student requests, additional one-on-one coaching, how does that fit into what the studio is running? So beyond those required policies we've touched on, the optional policies, which include the code of conduct, really start to get to the nuts and bolts of how are you going to run your studio, how are you running your business, and what kinds of expectations does it would you benefit from putting in writing?
Yeah, I would definitely flag overtime as a good one to have on the books, right? Just to sort of get a sense of these are the hours that I expect you to work, and if you work outside of those hours, this is what you can expect. That one tends to come up quite frequently. I showed up and stepped in under exceptional circumstances for whatever reason, and
Right.
And it's good to sort of know, both as the employer and the employee, what the expectations are around that.
Can you build a like workplace expectations that are outside of a contract that kind of apply to everybody?
Well, that would be really what the Employment Standards Act does, is it sets out, here's the vacation time that you're entitled to. Here are the ground rules for how overtime functions. Here's how pay works when you've got a statutory holiday. So if you've got a class scheduled on a Monday or a Friday, how are those being addressed? But otherwise, you can have a general code of conduct that you would incorporate by way of reference to an employment contract or to a student agreement that would apply to everyone. You can do it that way, absolutely.
Oh, harassment law. I think it's so it's so vital. And I think it's hard. Let's just talk about investigations a little bit, because I think that's the piece that really frightens studio owners, small business owners away from even building a policy in the first place, is because they just don't know how to deal with it, and how to even set it up. And I think that the key is that in not having anything, you're actually putting yourself in a much more dangerous position, because I mean, cancel culture is real. we have seen some studios fall to cancel culture of social media. And so I think it's really important that you try and manage not only the expectations of everybody who comes into contact with your studio, including parents of students who may be child actors, that you have some sort of investigative process that is manageable and isn't going to bankrupt your organization. We're going to provide a few links to policies that I have worked on or that I know of that I think are good enough, that are really address all the issues and have some sort of reporting process. But let's talk about a reporting process a little bit and what that might look like.
I think the first thing that I want to say is, I think when we use this word investigate, like with capital I, it becomes a bit of a black box. And I want to demystify the process and what it looks like. All it is one person meeting with another person who's levied a complaint or who has been named in a complaint and asking them for their side of what happened. And as you would often imagine in a meeting setting, you're recording that exchange of information in some way. Typically, it would be through note taking. There are some folks who like to record a meeting or a conversation, whether that's audio and video or just audio. I generally am a proponent of note taking. I find that's generally sufficient. And then you have the requirement that you're taking the information that you've gathered and you're arriving at some conclusion. Here's what person A said happened. Here's what person B said happened. And we have got these witnesses, X, Y, Z. And with all of that information, sometimes you're taking information back to some of the participants in the investigation to have them respond to specific points. You know, what's your report? What do you find happened? And do you find that what happened meets or does not meet, for example, in this scenario, the definition of harassment that Ruby stated for us earlier? That's all it is. So sometimes, you know, when you're doing it internally, stick to the bare bones. That's what you have to do. And if you you know, are able to, you know, ideally it's not a complaint levied against the person who would be conducting the investigation, rather. That's where it gets really complicated. That's where I've had some clients that have no choice but to retain a third party to investigate because it's just not possible to conduct the investigation in an unbiased way. But at the foundation, that's what it is. And not having a policy does not shield you from your obligation to investigate.
Ooh, that's a good one.
Yes. Let me just say, it does not.
Right. So whether you have one or not, you're still going to have to deal with it, right? Yeah, that's true. Ruby, do you have anything to talk about in terms of reporting? Like any thoughts about how to make it manageable for people?
I think what Madeline said, just, you know, making it as simple as possible. And again, something that you can adhere to is good, but as long as you're complying with the Occupational Health and Safety Act, right? Or, you know, the Employment Standards Act or whatever the prevailing legislation is that you're attempting to be in line with, just fulfill what they expect you to fulfill. I mean, in an odd way, that's the sort of larger, and now I'm diving a bit theoretical, but the law sets out expectations of behavior that it's expecting you to adhere to in the same way that your internal policy is expecting its workers and students to adhere to, whether that's an anti-harassment policy or a code of conduct, right? You're laying out the minimums of what you have to do. And as Madeline pointed out, even if you don't have that in writing, the legislation does require the investigation of you.
Yeah. And I also just want to talk about mediation a little bit too, because I think that that is sometimes a an option that people don't think of. It's a less expensive option than a lawsuit to try and mediate a solution. There are a number of companies now that you can hire a mediator to come in and try and resolve the situation should it escalate to that. A huge majority of complaints don't actually need to escalate to that. You can find a way to resolve the conflict, whether it be between you and your employee or between a teacher and a student. Um, there are ways that you can employ it, or you can deal with it. But mediation is also a way forward that it really just is an extension with somebody else helping to manage a conversation and can be a lot cheaper than a lawsuit.
Yes.
Go
I
ahead.
think there's a difference between having like a general workplace mediator come in to provide some sort of remediatorial information to a workplace after there's been a complaint and an investigation and an outcome. I see that kind of mediation as being distinct from uh, a mediation within the process of litigation, or a mediation between two distinct parties, either before a party has gone ahead and filed a claim. I think in those situations, something to think about is just whether all the parties have access to independent legal advice, because uh, typically in a mediation where you're reaching a resolution, there's money changing hands, there's some form of release that's being provided in exchange for that money. Again, I'm not sure what type of mediation you're referring to, but just to make sure that where you've got folks signing a release in exchange for money, that there's some opportunity for independent legal advice within that process.
Yeah, I think most of the mediation that I've seen is basically just like a conversation, having somebody help guide a guided conversation to seek resolution. Usually it's about an apology or about an acknowledgement of a wrongdoing, and just helping, because what we're talking about in acting is not necessarily about is about emotions. People's emotions get involved very quickly. That's probably true of most workplaces in any kind of complaint like this, that we're talking about people's feelings. But in acting, it can get even more complicated because the feelings are also part of the job. And that's not typical of other workplaces. So sometimes I find that the miscommunication is actually just about people just misunderstanding direction, or the conversation that was happening about the feelings that were happening. And so sometimes if you can't get past the listening and hearing and acknowledging stage, that it needs to escalate to a mediator who will help facilitate the listening, feeling, and acknowledging and potentially apologizing phase.
Mm-hmm. And
Just-
I'd be curious to get your thoughts on this, Ruby, but I would see that type of mediation as happening in conjunction with an investigation, so that the workplace is still in keeping with its obligations under the Occupational Health and Safety Act, but not as a substitute for.
Right.
Absolutely. Absolutely. That I think that that kind of mediation of bringing people together to have the discussion is it can be a very positive thing. Often in the case of if you're hiring a lawyer for a mediator, which I know might not be this case, but the benefit is also having somebody who has experience in mediation coming into the space as that sort of third party. And again, the third party doesn't have to be a lawyer, but it can be somebody who has more experience in mediating conflict,
Mhm.
so that both parties feel equally heard in in a case
Yeah.
where it's 1-to-1.
Yeah. Conflict resolution is kind of where I was going with the type of mediation that I'm thinking of more in particular, not arbitration, which can feel different. Uh, okay, I think we've covered harassment. I feel solid about it. I hope people aren't scared. The thing I want to tell you, if you are scared about building a harassment policy for your small studio and your 4 teachers, is that there are a ton of examples now. We will provide a resource list that has links to all these examples on the website and as part of the YouTube link, because you're just not alone here now. You're not building this in a vacuum. There are many people who have built incredibly good and very effective harassment policies for small acting studios, and you can get the help you need to build an effective one for yourself, your workers, and your students. Yeah.
Do you mind if I jump in? Because this is something I think, like, as somebody who grew up in the arts and worked in the arts and has transitioned into law, I feel very passionately, Madeline and I were talking about this earlier, about humanizing the law. And in, one of the things that can be said is, if you're feeling discomfort around that subject, that's normal, right? A lot of people that walk into our office and are sort of say, I've never been through the legal process before, you're like, yeah, it can be incredibly uncomfortable. But I think artists, and particularly performance artists and actors, are really well suited to sit in that space, because we're talking about conflict dramatically all the time. We're talking about objective and action, and obstacle all the time. And so it can be incredibly alarming when we suddenly, it's no longer in our fictional life, but in our real life. But just know that, as Jen said, you're not alone, and you have practiced this.
Yeah, thank you for saying that. I want to talk about liability a little bit, because I think that it's a factor here that you have to consider when you become an employer. And there's a number of ways that I think liability intersects with you as a personal liability, as well as your business, your small business liability. So can we just unpack what liability is first before we dive headlong into it?
Liability is huge.
It's massive. So let's unpack it a little bit, just how it might impact our special small group of people.
Sure, there's a wide range. There's all kinds of liability. There's the liability of if somebody comes to your house and they slip and fall on your driveway, right? If you're a homeowner, if you're a studio owner, same for your studio. If you slip and fall in the studio, we've talked about harassment policies, codes of conduct today, and then in terms of corporate structure, right? How if you have an HST number, if you've chosen to incorporate or not, how you structure your business is not my specialty. And so that is, again, a sort of question. I also don't work in insurance law. So if you have questions about liability insurance, for example, I would speak to an insurer about different packages that you may want to have. But there's all kinds of ways. The world is a wide and mighty place. And I think,
World of liability.
Yeah.
Oh,
but you want to protect your business.
Yeah.
That's the most general advice I can give is you want to protect yourself and you want to protect your business.
Right.
Anything to say about that incredibly wide space?
I think also, Ruby's brought up whether a business is incorporated, whether it's being run as a sole proprietorship, that's going to affect where the liability lies, right? Liability is basically just the law saying you're at fault for this, you're responsible for this. Usually what comes with that is you have to pay for this. So where you're running your business as a sole proprietorship. Again, this is somewhat beyond my scope, but generally you are responsible for the debts and losses that flow from the sole proprietorship. So if you are holding a studio in your name as a sole proprietor associated with X business, any debts or losses or liabilities are going to lie with you. So you may have some out-of-pocket expenses when someone is injured, for example, on your property, or makes a claim, setting out that they've been injured. Where you have your business incorporated, the incorporated entity functions as a person unto itself under the law, which provides you with somewhat of a shield to hide behind, for lack of a better word. So some insurances, again, this is not the primary area in which I practice, but some things to consider, whether you're getting in touch with a broker or dealing with an insurer directly, would be general business liability insurance, and also some home insurance, right? If you're operating your business out of your home, just make sure that your home insurance is up to date, that they're aware that you're conducting commercial activity on the property. How much space are you using? Where is that happening? It's likely going to increase your premiums for reasons I'm sure you can guess. Something also to consider is WSIB coverage. Based on my understanding of the audience for today, this is likely going to be optional coverage. I don't think that these businesses would fit under the mandatory WSIB coverage, but again, this would be something to look into. It's a way that,
can you?
Yes, the WSIB is the Workplace Safety Insurance Board. It's an entity that allows you to pay for coverage. So if an employee is injured on your property, the WSIB will provide income replacement and other supports to get that person back at work.
Copy.
That's one thing to consider. And then, the Occupiers Liability Act is something I also want to touch on. That's worth looking into, where you own or are responsible for the space out of which you're operating your business, especially if you're a sole proprietor, because what that act says is that you owe a duty of care to folks who are on your property. So that's something to look into. Again, somewhat beyond the scope of today, but I wanted to flag it.
Yeah, I think this is a really important conversation. And certainly I'm hoping to have an insurance panel at some point because it has come up more and more. I think part of what's happening is intimacy coordinators are being required to have personal liability insurance. And so that by extension, acting coaches are now being asked for this because they are also coming. So I've been seeing it more and more, and it's a growing question about personal liability and insurance when you are acting as a teacher and protecting your business. And so I wanted to flag it as something that people should start considering and start doing some investigation in, but just also know that ACE is also looking into this as something that potentially we can help with, because I think it's not too long in the future when everybody's going to want to have some sort of personal liability coverage if you're being hired as an acting teacher. That's my fear is what's coming down the road. But you should also really be very clear, if you are a sole proprietor acting coach working out of your home, what your and that means inviting students into your home, what kind of liability you have, and whether you can count on your home insurance to cover you in an event of something happening. And I don't know if that's always the case. And so it would be very wise to have a conversation with your insurance company, for example, to make sure that should somebody slip and fall in your house when they were there for a coaching, that you are covered, and that you don't need business insurance on top of that to protect your business. Fair?
Yeah, I think an example of where business insurance would be helpful is if something happened to your home and for whatever reason you weren't able to access it, and the knock-on effect that that would have on your business and your obligations to your students and your staff. So that's sort of something to think about too when you're relying on the availability of a certain space.
Yes, I can actually think of a recent example where a studio that I go to, the basement flooded and we had to move. We had to move for like 2 months. And, you know, it only because of insurance. I'm hoping that rent was covered in both places, right? So, yeah, I mean, we're not going to talk about rent. We're not going to talk about that because that's a whole nother panel. But yeah, becoming a small business owner and be getting into the world of commercial real estate. Yikes, a Rooney. That's a whole different thing. Thank you for going down the liability loophole. I think one of the last things I want to talk about there is disclaimers. And I think that's a really important thing that we should be talking about, because disclaimers are another level of protection beyond a code of conduct. That you can have a simple disclaimer about what you can offer. And Ruby has said it before we even started live streaming, that really managing expectations is the name of the game for your students and for your employees. And so what would be some of the things that would be helpful to have in disclaimer for an acting studio, do you think, Rube?
Well, I think the one that you and I spoke about, because I had questions of, what is the content of the disclaimer and where is the disclaimer located, are two questions I'd want to know. But if, for example, if you had a disclaimer on your website that said something like, we are an acting studio, not a casting agency, we help you, develop your acting skills, but we can't guarantee work, right? We want to help you get better at acting, but we're not necessarily here to employ you as a student, would be one of those disclaimers that I think is just helpful, again, as Jen said, to manage expectations, right? People are coming in, they know who you are, they know what you're coming to. Nobody wants to walk into Sport Check and realize that they're actually in, Bed Bath and Beyond, right? Like, I came here to get a volleyball and there are no volleyballs for sale. That kind of disclaimer is a very sort of general one that, again, who are we, right? There's always that tab on the website about us, right? That I think is useful, so that if somebody says, how dare you, I came in wanting to buy a volleyball, you can say, where did you find that on our website? What about our website made you feel like you could come and shop for volleyball here?
Right. Because I think, we have to remember that part of the branding of any studio in school is trafficking in the success of the students, and often promoting the success of the students as a way to get future students. And that is an important branding element of pretty much every acting school that I know of. But I also think it could be a bit of a sale tactic that can go sideways if you don't have a disclaimer that says you're not going to have their career. I'm not promising you their career. You have to make your own career, your own path. We can't promise you anything, even if you study here. What we can offer, what are the things that we can offer? I think it's important to be clear about those things. Also, because studios in school often have guests. They have guest casting directors, they have guest director lecturers. You know, a studio in school can give an impression of legitimacy in the industry that may make students feel like they are closer to or have some special relationship with, and those can be perceived wrongly if you don't protect yourself with a kind of disclaimer about how you are going to, what you can guarantee and what you can't. Do you see what I mean?
I think something that I want to highlight as well is the difference between a disclaimer and a waiver. And disclaimer is sort of a statement up front, whether that's in the About Me section on the website, or whether, you know, whatever the process is for, you know, welcoming students into your school. Is there a form? Is there any kind of application? That would be a place that it would be worthwhile to consider including the disclaimer as well. Disclaimers and waivers are subject to, you know, what can and cannot be enforceably opted out of by parties. So we've talked a little bit about the Employment Standards Act. The requirements in that act cannot be opted out of. But there's some question as to, you know, if you have someone sign a waiver saying that they get injured on your property, they agree that they have no claim. Okay, like, is that going to hold up in court? Would the disclaimer hold up in court? All of these would be live issues, but, you know, back to our theme of managing expectations, the more you have in writing, the more that you can point to, you know, chances are the better your argument.
And I do want to, I just want to jump in and support what Madeline just said there. You know, you can still have, even if your contract is the best contract that's ever existed in the whole wide world, somebody may still challenge it, right? Somebody may come and claim against it, but the clearer it's drafted, the better you put yourself and your business in a position in the event of hopefully that very unlikely occurrence.
Oof, I really like this idea of the difference between a waiver and a disclaimer. I just want to jump into a waiver a little bit. I have seen some acting studios make students sign waivers about what they will accept and not accept in an acting training environment. And I think the thing that you just said, Madeline, it reminded me to make this point very, very clear, is that you cannot waive away rights that are given to you by the law. You cannot waive away the right to not be harassed. You can't, even if you make a student sign a piece of paper that says, I agree to be choked, you can't sign that away. Even if you have that in writing, the law would say nobody can sign away their consent to be abused. Because that's not something that you can predict would happen to you and that you would know would be able to. So I think that's a very important thing to highlight here, because I have seen some studios have waivers for their students with a list of things that they consent to, and which I find very disturbing. Because of some of those things on those lists are things that nobody can consent to in the moment. Do you have a thought about that, Ruby?
I was just pulled back suddenly to my experience in law school and being told that consent has to be enthusiastic and continuous. That's one of my favorite things to pull out in conversation. I may have consented to something 5 minutes ago that I'm no longer comfortable with currently. And if I
Correct.
voice that I'm no longer comfortable with it currently, then my consent has been withdrawn.
Correct. That is huge, huge important thing to talk about is consent, because we have to acknowledge that everybody has the right to consent, their own consent, and that they can change their mind. So asking them to sign a waiver that would waive away their future consent is not a thing. You cannot do it. And there's if it ended up going to court, you would lose. It's because you cannot ask somebody to do that. We have about 8 minutes. Is there anything else that you want to say in closing, either of you, to our overworked and our tired acting studio owners who are just trying to keep their business going? From a legal perspective, what they can do.
I think less is more, and that's come up a few times. I live in this little world, and I appreciate that our audience is having to take this in and fit it into the matrix of other administrative and all the other elements of running their business, the marketing, the branding, all of that. It's huge. I
Yeah.
think we've touched on a lot today. In some ways, once you start to dive in, I've got all these specific points that I sort of need to get through. But I think at the foundation of today, we've got three basic policies to think about. Those don't have to generally be longer than 1 or 2 pages. Then you have some general insurance issues. That's a couple phone calls. I appreciate that it's a significant undertaking. I appreciate that there may be financial constraints. Insurance, I was just traveling and I thought, oh shoot, am I going to take out insurance? What are the chances that something's going to happen when I'm traveling? Like, it's all just a function of your appetite for risk, your threshold for risk. Is it easier for you to pay a couple $100s now? Are you willing to sort of just fly by the seat of your pants and hope that no one has a catastrophic injury on your property? No one can tell you what the right decision for you is, because there's the law and then there are the business decisions, and that's where the rubber hits the road. It is entirely in your hands how you choose to proceed. All that Ruby and I are here today is to generally give you some idea of what the landscape is, and what you do with that is entirely up to you. It doesn't have to change how you run your business. It doesn't have to change all of how you run your business, maybe just a small part.
Yeah, I would definitely second everything that Madeline just said. I think that appetite for risk is a huge factor, and that is a very individual question. And it's been our pleasure, if I may speak for both of us, to speak here today about these general concepts. And if you have further questions about the specific ins and outs of your business, reach out to a lawyer, right? And it's the same as an investment risk, a financial investment risk, right? You're talking about how much you're comfortable, what Madeline spoke to in terms of travel insurance, and what occurs, I would say, just to like plug, if I may, a somewhat related but separate issue, get a will. Another question of risk. And again, there's only so much that can be contained within it. If you want to talk about the zombie apocalypse, I don't know that I can help you, but right. What you know best, what you've encountered in terms of your business model. And it's always good to discuss that.
Yeah. And I think I think one of the things that I just want to touch quickly is that there are slightly different considerations for people who work online. A lot of coaching practice has moved to an online atmosphere. And even though you are still in an online relationship, you still have liability issues there. And that things could happen still in an online. It may not physically be able to happen, but you still need to have some considerations for harassment when you're talking about an online relationship, if that's a teaching environment, right?
And also in terms of your obligations as an employer, again, we're sort of skipping over the analysis and assuming that you are in fact an employer, that those obligations to your employees persist regardless of where and how those employees are doing their work.
Right. Yeah. So regardless whether you're in person or online, the law applies. Good to
Yes.
know.
Yeah, I was just Googling, what the workplace, and any land, premises, location, or thing at, upon, in, or near which a worker works. Right? So
Well, there you go. That's the
then
virtual world too.
There's this whole other world too of where you have employees doing work elsewhere for a business. Are you liable for their space? It's a real live issue in these days of remote work.
Yeah, post-COVID. Yeah, for sure. Remote work. Well, remote work has really affected our business in a significant way, in many, many aspects. And live coaching on Zoom is a real thing. I do most of my coaching on Zoom. Um, um, so I think you can also record, like you can record those sessions, which is some coaches have been recording all their Zoom sessions, just as a liability piece, just to have it. You never know, and that can be something that you get all your students to agree to. Right, as a waiver that you start, that this is just a way to protect everybody, to have those sessions recorded, so that they can go back and forth.
Oh my goodness, which introduces some privacy considerations. It's, never a dull moment.
Never a dull thing. Yeah, privacy. We don't even talk about that, but yes, that's something for people to consider, employers to consider about the privacy of their students and how they handle their emails and how much they contact them, and, consent for using their likeness to promote their business, that kind of stuff. These are important considerations that all come back to the health of your business and protecting your business for the future of your business. I'm so very grateful. I've learned so much today, and I hope that this has been incredibly helpful for you all. I know this is really difficult stuff to talk about. It's challenging. It can be dense at times. I hope we've broken it down a little bit for you so it's not quite as scary. I think if I was going to say anything to remind you that you are not alone, that there are many, many, many people who have gone down this road before you, who have helped build policies and help build practices and codes of conduct and disclaimers and waivers and all those things that you can get access to help you build your own in your studio and help protect your business. I want to thank our incredible guests today. Thank you so much for your help in us navigating some of these things we don't like to talk about. I find it itchy to talk about it because it's something I could just forget about. But I think ultimately it's really important that you just have to rip off the Band-Aid and just address it so that you're not caught with your pants down, kind of horrible analogy, right? You really need to prepare yourself in the event of, manage your risk, right?
An ounce of prevention, as they say.
Ounce of prevention. Yes. Thanks so much. Any last words, friends?
thanks for having us here today, Jen.
Thanks for your time. We really, really appreciate it. Bye.